treated this subject here with a lawyer. Now we're treating it with those the state has established to be responsible for ensuring that there is sanity in that space as far as renting a premises is concerned. When you are in trouble with your landlord or with your tenant, how do you go about resolving it? How does the state expect a resolution to be arrived at? So we are treating landlord or landlord, tenant, and rent control. We'll be right back. Many tenants are reeling under the dictatorships of their landlords, dictators in their homes. From expensive rents to impracticable rules, living under a difficult landlord-landlady can be frustrating. Listen to the story of Joseph from Dakuman in our case for today.
It's not easy, though, but we are trying to manage. Yesterday, he came complaining that there's a bill that we have to pay, and it says 200 cedis each tenant. And we're asking to at least give us a paper which shows that we are paying 200 cedis. He says no. And he said if we're not ready to pay, unless we won't allow you to fetch water from the house, unless you go outside our community. So yeah, they're paying that's 3,600 for 2 years. After 2 years, he said we have increased it to 4,000. The landlord is not being fair to us, unless our house is gated house, and he has stated that after 10 p.m. he will close the gate. If you are late, unless you sleep outside, they should just come out with some laws that maybe we the tenants, if any problem, we can come to them. And also, I'm suggesting that those, how do you call it, agents, it's not helping at too.
You're welcome back. So, as always, we will be opening the phone lines and give you the opportunity to join us to ask your questions. This time you ask them directly to the people that the state has mandated to help you have a comfortable rental arrangement. So joining us this afternoon for this discussion is Emmanuel Kporsu, who is the Public Relations Officer, Rent Control Department. Thank you very much for making time to join us.
Thank you, Samson.
Great.
And it's a pleasure being here.
Great. Right. So, from where you sit in your office, I'd like to start from this point of view. What are the most common things that landlords and also tenants complain about?
Okay. Samson, before I answer your question, I would like to express our sincere appreciation from the Minister of Western Housing, Francis Asenso Boachi, and then Frida Brempe, as well as our Chief Rent Officer, Chuman Pofu, for this opportunity. So to come to your question, when it comes to landlord, most of the problem they bring to us is rent arrest. Just if you have to quote from 2019 statistics, about 72% of the cases that came were on rent arrest, which means a lot of tenants are not being able to pay their rent. So that was very massive. And then again, when it comes to tenants, the issue has to do with inducing them to quit and also claiming their refund of rent advance, which means they've paid advance and now, due to some circumstances, they have to move out from their premises. And now they are now chasing their advance and it's not coming, so they refer those things to us. So these are the two major, or if you like, three major issues that come to the Rent Control Department.
Right.
Yeah.
I know that there are certain steps. The former minister, Atacha, had announced that there are steps to ensure that there's some changes in the law, including particularly for the period that rent advance can be taken from, or be demanded.
Yeah.
I don't know how far that has gone, and if you are able to share briefly with us about that and what that will bring to change things within the, landlord-tenant relationship. So,
Samson, just what you just referred to can be seen under Section 25(5) of the current Rent Act. That is the Act, Rent Act 1963, Act 220. Under Section 25(5), it says, any person who has a condition of grant, renewal or continuancy of a tenancy demand in the case of monthly or short tenancy, the payment in advance or more than a month's rent, or in the case of a tenancy exceeding 6 months, the payment in advance of more than 6 months' rent, shall be guilty of an offense and shall, upon conviction, be liable to a fine not exceeding 500 penalty units, which is equivalent to 6,000, or a term of imprisonment not exceeding 2 years. So this is what currently persists. But in the new bill, which has been laid before Cabinet, which Cabinet has to review and then pass on to Parliament for them to just pass it and then go back to the President for assent, it has been stated that for short tenancy, we are still maintaining the monthly payment of 1 month. And then for long tenancy, now landlord will have the leeway to charge 1 year rent advance. But until that has been approved and then passed by Parliament, it's currently 6 months maximum rent advance that landlords are mandated to take from tenants.
And that's according to Section 25(5) of the Rent Act. Is an offense.
Yes.
So, once again, lay out the sanctions for that offense, and I'll get you to explain some portion of it again.
Okay. So, the sanction there is, if you flout this act or this section, you'll be liable to a fine not exceeding 500 penalty units, which is equivalent to 6,000 cedis, or a term of imprisonment not exceeding 2 years.
Right.
Yeah.
So 500 penalty units. A penalty unit is 12 Ghana cedis.
Exactly.
Simply multiply 12 by 500.
Yeah.
So if you charge rental advance in excess of 6 months, Ghana law is that you are committing an offense. And if you are found, you could be charged or be asked to pay a fine not exceeding 6,000 Ghana cedis. Or in addition to the fine, you could be going to jail not exceeding 2 years. You don't want this. We will get to why this is not enforced at all and why that may have influenced the need to also increase the period that the rent must be paid. So presently, the law doesn't say, I can't give my property or my apartment for rent for more than 6 months. That's not what it says.
No.
Please explain.
Okay. So when it comes to short tenancy, you can sign an agreement with somebody that I'll be taking monthly rent advance from you. If you sign that agreement and then you go sideways and then now you say, no, I've taken 2 months already. Next time I'm coming to take 2 months, or I've taken monthly for the first 3 months.
Okay.
Now I'm coming to take 2 months. This constitutes an offense if it comes to the short tenancy.
Okay.
When it comes to the long tenancy, the law or the act is stating that for long tenancy exceeding 6 months, which means you can sign an agreement with somebody for 1 year, 2 years, 3 years, and above.
Right.
But when it comes to the payment, you are not supposed to demand or even collect. The law says don't demand and collect. So if you sign 5 years tenancy agreement and you come and demand 7 months rent advance from that tenant or prospective tenant, as we call them, you commit an offense.
Right.
And these are the sanctions, just as we've explained, based on the discretion of the magistrate. He or she can combine the fine and then the imprisonment on you.
Right.
So this is the caution we are sending to landlords.
Great. So it is clearly possible to give out your premises for more than 2 years, 3 years, but there's a policy reason why you shouldn't take the rent for more than 6 months, because that's just not fair. Now, in this circumstance, we have found a reason to increase the rental period to a maximum period of 1 year, which is the bill you say is before cabinet and is being worked on. Hopefully we'll get to Parliament to be passed. What informs that?
Okay. What informs that is the fact that the investment in real estate is increasing. And then before this bill, which has been laid before cabinet, a lot of stakeholders meetings were held. And then it came out that, no, if you still maintain the 6 months, it will take a very long time for the prospective or the landlords. There are no landlords aside. Who explain who a landlord is and who a tenant is. So these real estate developers, let me call them this time, it will take very long time, though it should be in their mind that this real estate business is a long-term investment. They should understand that. But though it's a long-term investment, it shouldn't take very long time for them to recoup their money. So that's informed the 6 months, the increase from 6 months to 1 year. Yes.
Right. Okay. Now, we will put that aside for now. And as I told you, get ready with your questions and your circumstances. We have one issue at hand. We will get our guest to respond to that. And remember, Emmanuel Kporsu is the Public Relations Officer of the Rent Control Department, and he's assisting us this afternoon. So any question at all you have about landlord and tenant, he's more than capable to respond to you on it. Now, when I'm going to rent, what are the expectations? What should I look to be doing with the landlord before I even get the property?
Okay. So something, there are some 5 basic requirements onto a landlord. And when you come under from Section 10 up to Section 19 of the Act, it talks about what we call an assessment. An assessment is when you finish building your premises. If you want to dwell in personally, the Act does not inflate on you. But when it comes to mind, I want to put this property on a commercial platform to get money from it. This is where you are mandated to follow the guidelines. It's just like doing a legal business. You can't afford to look down on the Registrar General. You need a certificate, a business certificate. In this COVID period, you can sit in your room and then prepare a concoction that can cure the COVID. But you need to go to FDA for them to approve it. Similarly, if you finish building your premises and want to put it on a commercial platform, you have to apply for what we call the assessment. Assessment is where the rent control officer or the magistrate will come to your premises, look at the premises and find out whether it's tenantable, whether it's a place where somebody can dwell in. We look at the materials you use, the fittings, the location, the property rate you pay, the maintenance responsibility. If it has to be the landlord, we factor all this into it, and then we give you what we call an assessment certificate. This assessment certificate will indicate how much you are to charge for a period of 2 years. So the rent on your premises has to be determined by the rent control officer or the rent magistrate. After you've acquired this certificate, that will give you the mandate, the order to advertise for your premises. You have the right to use what we call the agent, or we have 2 registers at the rent control department. One is the vacant premise register, where the vacant premises of apartments which are ready for rental, we put in there. Then the other database is the prospective tenants database. Those who are roaming looking for apartment, if they also come into our offices, we look at their requirement. If it suits any in our database, we call the landlord, we link the 2 of you together to go and document your processes. So after you've gotten this tenant or prospective tenant, what the law says under the PNDC law, the LI 369, that is the rent control law 1986, PNDC law 138. If you look at section 4 of that.
So we will be advertising the Zoom and the phone lines so that you can get in touch with us. And now remember that if you haven't heard anything so far, Emmanuel has pointed to one fact. If you're a landlord, if you're a landlady, you must be a law-abiding citizen. You live in Ghana. Once the property is ready, and your decision is that you don't want to use it for yourself, but you want to rent it out, you don't just get up and start advertising it for people to come and live in it. You must first make contact with the rent officers. Then an assessment will be done. It is that assessment that will indicate how much you will charge for monthly rent or for the advance that you require. He said they will do an assessment to know whether your premises is tenantable. Tenantable in law means the place is fit for human beings to live in. So he's looking for a certain provision in section 4 or so of the Rent Act to tell us an additional information.
Okay.
Yes.
So just on the point you read, under section 19 of the Rent Act 220, section 19.3, it says no landlord or person interested in any premises shall collect in the increase of rent attributed to the increase in rate in respect of any period before such increased rate were assessed. Okay, so now I come to the PNDC law 138 under section 4. It says, section 4.1, it says every landlord of any residential accommodation referred in this section 1 of this law shall register with the rent control department every lease and tenancy agreement in respect of such accommodation within 14 days of entry into the lease or tenancy agreement. And then 2 says, no landlord shall demand or receive from the tenant of any residential accommodation the rent in respect of such accommodation without complying with the provision of subsection 1 of this section. So you cannot demand or take rent advance from any tenant without registering the tenancy agreement with the rent control department. So when the tenant comes, after you've gotten the assessment certificate, you give the tenancy agreement for the tenant or the prospective tenant to read understand, and if he agrees, or he will then sign. After signing, it's your responsibility as the landlord to come and register this tenancy agreement. The notion or the idea behind it is that as a rent control department, we have to make sure that the right of the person coming to your premises is sealed. You don't have to, tenancy agreement is not an infringement you are infringing on somebody. It's a mutual agreement. So we have to check and make sure that the provisions you put in the tenancy agreement does not infringe on somebody's human right. We have to take the Constitution into consideration. We have to take the Act into consideration, and then even the universal right also. We have to take all into consideration. So by registering this tenancy agreement, we will check whether everything is okay. After that, then if you give you the go-ahead, now that you can go and demand and collect
the rent.
The rent.
So number 2, you have done the assessment. You have been given the go-ahead by the state through its representative agency, the rent office, that the place is fine, people can use it, and this is the amount to charge. Then next thing is, when you are entering into the tenancy with the tenant, remember when we dealt with this subject here, Lawyer Hanifa Yahya explained that the law requires that the relationship must be governed by a contract. So the two of you must sign. Of course, if it's just a shorter tenancy, there's a requirement for a rent card to be given to you by the landlord. I don't know if they do it anyway. Right.
We'll get there.
Right. So once you sign the agreement, Madam Landlord, Mr. Landlord, you are supposed to take that tenancy agreement to the rent office to lodge it with them. Right.
Okay.
Proceed.
So, again, on the tenancy agreement, under Section 25(1)(e), it says, every person who in respect of any premises enter into or carry out any fictitious or artificial agreement which has the effect of attempting to defeat the object of this act commits an offense. So these are the idea or the notions behind you registering.
Does it end there, commit an offense?
Yes, commit an offense. No, you know, these are the offenses.
Right.
Okay, so any person who does anything contrary to this commits an offense.
All right.
That is the general perception. So what we are saying now, we've talked about the tenancy agreement. We have a very nice picture here, which we call the rent cut. The C, these are acronyms. We have the card, agreement, receipt, and tax.
Okay.
So we'll explain. The C there is the rent card. So after you register the tenancy agreement.
We have it, but it's a bit blurred.
Okay.
We will try and still upload it and see how it looks like.
Yeah.
But it's a bit blurred.
Okay. So the C, as I said, is the rent card. And this can be found under Section 20 of the Act. And it says, every landlord of any premises on monthly or short tenancy shall issue to the tenant of such premises within 7 days after the commencement of the tenancy a rent card specifying the name of the landlord, name of the tenant, the amount that has been agreed or that has been approved, and then any other prescribed particulars. So it is in the law. This is the rent card.
Okay.
So we have the details of the landlord, the details of the tenant, and then other particulars.
So the landlords must come for this from you.
Exactly.
And then they will give it to the tenants.
Exactly.
That is those who are coming for shorter tenancies.
Yeah, for even short and long tenancy.
Okay.
But the law says that within 7 days after the commencement of the tenancy, this card must be issued to the tenant.
Okay.
And it comes in two. So whatever information is in one is exactly what is here. So you give one to the landlord, no, you give one to the tenant, I said, because it's the responsibility of the landlord to issue this.
All right.
When you look in there, you can see 4 portions. It's a yearly portion.
Okay.
That does not mean you can take the rent advance for the 4 years. Just as we explained,
right.
you can sign an agreement, tenancy agreement for
as long
4
as
years. But currently, the law demands that the maximum rent advance you should take should be 6 months. Again, when we come to the details, there is an emergency number or a guarantee number that must be provided by the tenant, so that in case something happens to the tenant in the house, you can get somebody to fall on and get a necessary assistance. Or even if the tenants run away, it deteriorates your premises or is even owing and run away, we can still use this number
to
trace the person. So this is the rent card.
Okay.
Okay. The next one is the agreement, the A, which we've talked about.
All right.
The next one is receipt. The law demands that instantly when the money is paid to you, you have to issue a receipt to the tenant. And that can be found under Section 33 of the Act. And it says, at the time of payment to a landlord of any sum in respect of rent for the premises or a rent for premises and for the use of furniture or features, such landlord shall provide the person making such payment with a receipt in writing, duly stamped if a stamp is required under any enactment for the time being in force, specifying the premises in respect of such the rent is paid, whether the premises is furnished or unfurnished, the amount, the period in respect of which the payment is made, and the name of the tenant. So the law demands that instantly you have to issue the receipt.
Okay.
The last acronym is the T, which is rent tax. When you go under Section 115 of the Income Tax Act 2015, it mandates every landlord who has collected rent to pay rent tax.
Okay.
If it's a commercial premises, the law requires that you pay 15%. If it's a domestic, you pay 8%.
Okay.
So the landlord should take note that every rent that they collect, there are taxes that they have to pay.
Right.
8% for domestic, 15% for commercial.
Commercial. All right.
So these are 5 basic things apart from the assessment. This is what we call the rent card. Every landlord, it's basic that every landlord should abide by.
So the rent cards, it's cart, C-A-R-T.
Yes.
And as you can hear him explain, the first one is about this card that must be issued. And you see, for you landlords, sometimes you may even forget. You don't have good memory, a way to keep any good books. Once you issue this out, you have a copy. The tenant also has a copy. Every month, once they are paying, you are ticking. All of you are ticking. You are signing. So it makes things, a lot tidier, nicer. Then after the card is the A, which is agreement. There must be an agreement. And that agreement, like he said earlier, must be lodged with the rent office. Then there is the R. There must be receipts for the payments that have to be made. And then there is the T. That is the tax. Once you take money, you must pay tax to the state. It's just like you're doing a business. You take money, you are either paying withholding tax, you are paying VAT. That is how every nation is developed. You're still here on the law, and we're treating landlord, tenant, rent control. And we are so privileged to be hosting Emmanuel Kporsu, who is the Public Relations Officer of the Rent Control Department. We're going to open the phone lines now, and our Zoom contacts are also open. You can make contact with us now. Whatever your questions are, we will take them. I have Columbus. Columbus, you are calling us from Nkoko. Let's hear you. Okay, we don't have Columbus. We lost you. Okay, so hello, Bernard. Okay, I don't know what is happening. Bernard, your line just dropped. Too many of you called and your lines are just dropping. Hello, Fred.
Hello.
Yes, Fred, what's your question? Where are you calling from?
I'm calling from Akimoda.
Okay, Fred, let's hear you.
Yeah, I rent an apartment and the landlord took 3 years advance. The daughter of the landlord came suddenly. I've been in the room for a year now. Suddenly, the daughter came and said, the rent is too low. The father collected, the price is too low. So she has to evict everyone from the house and then increase the rent again.
You said you have rented an apartment and you paid 3 years advance.
Yeah.
And then what happened?
The daughter came one day. I've been in the room for 1 year now. The daughter came and said the rent that the father collected, the price is too low. So we have to just increase the rent or she's going to evict everyone out of the house.
Okay. Did you sign a tenancy agreement?
Nah, he doesn't do that. No tenancy agreement, nothing.
Oh, why? Okay. Thank you very much. Your name again is Fred, right? Okay. So this is first Fred. We have another Fred, Fred Tema. We take yours and then we take answers. Hello, Fred in Tema. Fred.
Yeah, hello, something. Good afternoon.
Good afternoon. Go ahead with your question.
Okay, because the one who ended the call, what is there are some of the tenants, the landlords who doesn't issue those cars to the tenants. Is the rent control actually doing something going on there from the tenants to know if they are getting those cars? Because it seems some of the tenants don't have those cars and anything can happen at any time. Some of the landlords somebody has to take over without even knowing how the agreement
Okay,
went
thank
by.
you. You want to know what the rent control is doing about that situation. Okay, Constance. When I take Constance, please indulge us. We'll let you hold on a bit. We'll take some answers before we come for some more. Hello, Constance. Where are you calling from?
I'm calling from Tema, please.
Okay. Are you Constance?
Yeah, Constance.
Okay, go ahead.
Yeah. I am a tenant. And normally, landlords, what they do is, can you hear me, please?
Yes, tell us about your case. Don't talk about the general situation.
Yes, in my situation, I rented a place for 4 years, and just after 2 years, like my friend said, the landlord said he's increasing the fare again. He's increasing the tenancy again.
Okay. And you want to understand why? Because you don't agree.
Yes.
Okay.
Normally they complain that building materials are going high, and that is why. But that you've already built the place.
Yes.
Why, even if building materials are going high, you've already built the place and you've taken advance from.
All right. Thank you, Constant. So let's look at them. Let's start with him.
Okay.
What's the basis under which a landlord can increase rent? I think that is his question.
So in the first place, no landlord has the right to increase its rent without consulting the rent control office.
Okay.
Under section 19(1), it says, no landlord of premises shall collect from the tenant of such premises any increase of rent attributable to any increase of rate in respect of such premises, unless he has notified the tenant previously in writing in a prescribed form the amount of the old rent, the amount of the new rate, and where part of any premises has been let, the amount of rate attributed to such part, the amount of the increase in rent, and the date from which the new rate take effect. So under section 19, so when you come to section 19(3), that's where it insists that no landlord should collect any increase in rent until that premises has been assessed. So when we finish assessing and we give you the rate, that's where you have to notify the tenant that from next month going or from the next 2 months going, I'll be charging you this new rate from this old one which I'm currently collecting.
And this new rate has been approved by
the rent control department or the magistrate.
Okay.
And then Fred from Akimoda, the issue is just similar to this, but it's illegal. It's contrary to the act for the landlord to collect even the 3 months rent.
3 years.
3 years, sorry. And now, because there is no tenant, but verbal agreement is an agreement.
That's right.
So if you've agreed that I'm going to stay in your premises for 3 years, you've taken this illegal advance from me. The daughter coming in that the rate is too low has no right to go and demand any money from the tenant. You have to wait when the tenancy expires and want to rewrite or want to come into new agreement. Then you can sit down with them, come to rent control. Let's come and do reassessment and check whether the money you want to get from them is reasonable before you can take that money.
Right. But Fred's bigger problem is because he did not enter into any written agreement.
Yes.
Whilst an oral agreement is fine, there is a reason why in Ghana law, when you are dealing with anything that has to do with land, the law says the agreement must be in writing. So if we are dealing with a rent, you can take it without a written agreement, but you are in a disadvantageous situation. If you put it in writing, then that document will be there for everybody. But if you do it orally, the other party can tell you, your landlord can say, this is not what we agreed. You gave me money which you say is for 3 years, but I understood it to be for 3 months. And you'll be in trouble. So always, it is good to insist that you execute an agreement, a tenancy agreement. They want your money. So why are you in a hurry to say, I want a place, so if they are not signing an agreement, it's okay, I'll go and give the money without signing one. Yes, so it is not good for you. You must always demand and get one.
So something, this leads us
what should they do in the situation?
Okay, so this leads us to the second thread of Tema. The cut issue that we've talked about, it's your responsibility as a tenant to demand it from the landlord.
Right.
If they are refusing to give you such document, come to the rent control department because it's a legal mandate that they should issue those documents to you. So this, just as you said, the tenancy agreement is mandatory. We have to insist that it gives it to you. So when it comes to such circumstances, because these are the tenant's own words, we use natural justice, okay? So the tenant can visit any of our offices, lodge a complaint. We invite the landlord. If we invite the landlord, we'll listen to his side of the story, find out the truth in it, and then we insist where the law applies, we apply it. So the tenant can come to the rent control department, then we'll assist him or her with such issue.
Great. You can always have a mutual agreement. The daughter shouldn't show up from nowhere and say the rate is small and you'll be evicted. So the question of he being threatened with eviction, which is what most landlords will do. Under what circumstances does the law permit eviction? And what can somebody who is being evicted, who feels is being badly dealt with, do?
Okay.
Or what can you do for them?
Okay. So the first issue is that if you report a landlord or landlord is going contrary to the act and you talked and the person wants to evict you, that constitutes an inducement. But under Section 17, there are laid down procedures under which a landlord can claim or recover possession.
Yeah.
The first issue is that you as a tenant has no right to owe any landlord a month's rent.
That's right.
Okay. The second one, so if I have to read, okay, so recovery of possession under Section 17.
Right.
So A is where any rent lawfully due from the tenant has not been paid or tendered within 1 month after the date on which it becomes lawfully due. B says where an obligation of the tenancy other than that specified in paragraph A, so far as such obligation is consistent with the provision of this act, has been broken or not performed. And then C, where the tenant or any person interest residing within him has been guilty of conduct which is nuisance or annoyance to adjoining occupants. D, where the tenant or any person residing with him has been convicted of using the premises or allowing the premises to be used for an immoral or illegal purposes.
Okay, so C and D.
Yes.
C and D, if you are in my property as a tenant and I'm the landlord, and you are doing things that constitute nuisance, annoyance to other people who live around, what are these things? Nuisance and annoyance. And then if you have been convicted by a court as having, you are using the property for the purposes of immoral or illegal activity. What are some of these? Mention them to us so that we know them for a fact.
So for annoyance, we take a tenant, for instance, midnight, you are the only person who like loud music. Okay? You'll be causing nuisance to other occupants, even to the landlord as well. For the issue of immoral, illegal purposes, not even the rent officer has the right to determine what an immoral or illegal purposes is. So when an offense has been committed, in your opinion, as a landlord, you first have to lodge the complaint. We'll pass through the process, send it to the court for the magistrate to determine what an illegal or immoral activity is.
Okay.
Before, if he's convicted, you can stand on and then evict that person.
Okay.
But you just don't wake up that, let me just put in this lesbian issue, that you think they are performing illegal purposes, then you just call the police to come and evict them. It's absolutely not right.
Okay.
You just have to let the court or the magistrate determine if that is illegal and immoral.
All right. So
Yes.
you hold on. I'll return to you. We can take a few more, but get ready to give us a summary of the things that you will do and your landlord is entitled by law to evict you.
Okay.
Right, because there are many of them that the law lists. So please, landlords and landladies, the law is not against you. Don't think that way. All right, so let me do this. Let me take a quick break. I'll be right back.
Yamwa baba kase boiso. Efra me vim lady, efia pokuya. And na wiase aye hu. Esan say yare adoso enketwa ne akese. And I'm so me ebusan krofo say apomudin ma papa. And he say
apomudin ni say obebo adwuma akwa ba onti brebia.
Ahonde mrosro. So be sipi sita. Ana. Se obeye bo heavy. Debia.
oyiwa obia fa hoden, obia penkwa. Edro ni ni. Hepa plus mixture. We na onomo a enkwamwa na nya ahode akweti anyare wo bia ebeba oni pedua ni. Hepa plus mixture ema apomudin mapa.
Hepa Plus Mixture, a woman pedweni jina yepa. Hepa Plus Mixture, and young man na wondi fedu menu. A pinfo, and na batai. FD Ashisha Saja de Cratwim. I jatum say a ye.
Hepa plus mixture ema apomudin mapa.
You're welcome back. This is The Law. It's your legal light and help law. And our guest is Emmanuel Kporsu, who is Public Relations Officer of the Rent Control Department. Now, let's take some more of your questions. Yes, Kofi, let's hear you. Kofi?
Yeah.
Yes. Where are you calling us from?
Yeah.
What do you have to say? Hi.
Yeah, good afternoon. I'm calling from Adesso. My name is Kofi. Yeah.
Okay.
Around in Tamam.
Right.
Yeah. I'm a landlord. I'm a landlord, and somebody rented my place. In fact, the place wasn't completed. It was half completed, but a person gave me 1 year advance, and I completed the place for her. But later on, after some few days, she came that because the place is not fully completed, she is no more interested. Yeah, so he said I should rent the room to another person and give her her money. But up to now, nobody has come. Nobody has come for the room, and she's still giving me pressure. And I also don't have the money to give her. So what should I do?
All right.
Yeah.
Thank you, Kofi.
Or is there any law
Kofi,
that can, make me a victim?
Kofi, we have heard your question. Thank you very much. Kofi is a landlord in Adesso, and many people face this situation. Who do we have joining us via Zoom? Hello, Pastor Max. Can we hear you?
Hey, Samson. Good afternoon or good morning. It's good morning here. I'm Pastor Maxwell. I'm in the U.S. Now, I think hearing you this morning and your guest, I think most of us flout the law, when it comes to rentals and stuff,
Yeah, right.
I have my question is, I have property in Ghana, right, which currently I'm renting out. Now, I have two questions. One question is, if the term of the tenant expires, okay, now what I keep hearing is they have 3 months grace period, okay, which I didn't hear your guest mentioning. Is there any grace period when the tenant's agreement elapses, and what happens during that time that the contract ends? Where is subject to renewal? Is it you have to give the person 3 months for him to renew the contract again, or what?
Yeah, to your next question.
This question is, now, in the law, do we have anything that says that maybe a tenant can put down a down payment? Let's say, over here in the U.S., when you're going to rent, you have 1 month to down payment, okay? And the rest of your payment is, ongoing. So the down payment is such that when something, you messes up something, that 1 month payment is
clearly understood. Clearly understood. Cool. Thank you, Pastor Mark. Thank you, Pastor Max. Right. Your issue is clearly understood. Two clear issues there. Hello, Elijah.
Hi.
Yes, Elijah, let's hear you.
Yes, so my name is Elijah. I'm calling from Bolga. My first question, I think, is what Mark has already answered. My second question has to do with the tenancy agreement. And so at what point of the agreement do you need to get the tenancy agreement? And is there a requirement that if, for instance, a tenant, you receive the tenancy agreement, you share with maybe someone who has legal, but maybe a lawyer or something, before they sign?
Thank you very much.
What does the law say on that?
Thank you. Okay, so, and I need you guys to hold on so that we can quickly go to your, go get answers for you. Okay, right.
So, Pastor Mark, the 3 months is not in our books. What happens, or what should happen, is that when you sign the tenancy agreement,
exactly,
for 1 year, 2 years, 3 years, there should be a clause in the tenancy agreement,
right,
that when it's 1 month or 2 months for my tenancy to expire, we will meet, for me, the tenant, to tell you, I want to renew or I'll quit. So it's not within the domain of the tenant to wait till the end of your tenancy before you start running to the landlord or to the rent control seeking for a grace period, as we call. There's no grace period in the Act.
If there is any grace period, it is you or a court that will give.
Exactly.
After the tenancy has expired. If it expires, it's expired.
It has expired.
Okay, next.
So the security, what we call the money they put down, they call it security deposit. Some even are going ahead to term what we call goodwill.
Yeah.
We may have time to go into details, but within our laws, there is nothing like security deposit. it is mandated on the tenant that when you are moving out, you make sure how you came to meet the place, you leave it exactly. If you deteriorate somebody's premises, you are mandated to repair it before you move out. So this security foreign thing we are importing into our system is illegal.
However, because you are entering into a written contract, as in tenancy agreement with the tenant, you are allowed in law to determine the terms. So you, the tenant, and the landlord can agree that you are putting down X amount of money so that in case you are leaving and you don't paint the place, is dirty, wiring is terrible and all, you take care of it. So you use that money to take care of it. That's two of you, individual, agreeing mutually. It has nothing to do with the rent control people. Right.
Okay.
Right.
So with Elijah, because the tenancy agreement is more like a legal document, we have samples in our offices.
Right.
If you cannot come to our office, you need to seek legal advice. Contact any lawyer to help you draft this tenancy agreement.
Great.
Yes.
There are some people who don't feel there's a need for a lawyer in this. And there are landlords who say, I will bring you one, you know, that's it, take it or leave it. Look, they want your money also. Don't always think that you are a victim and you must give because they want your money. All right. One of the Freds had asked a question which we didn't answer. His question was, what are you doing as a state organization to educate tenants and landlords to know that they need the rent card and all of these things?
Yeah, we've admitted that for the past, if we take the Rent Act, 1963, massive education have not gone on.
Right.
But for the past 2 years, we've done a lot of massive sensitization program. It's still ongoing.
Right.
And we are grateful to most of the media houses who are opening their doors for us to do this sensitization program. So it's ongoing, just as we said. But we need to do more. I admit, we need to do more.
Right.
So we'll get there.
Right.
We'll get there.
Actually, because of your sake, Emmanuel is agreeing to return to us so that we do a part 2 where you will ask a lot more of your questions and then he will simply provide you answers. I think I can take one more. Hello, Charles. Charles, you're calling from Kede. Let's hear you.
Yes. Please, I want to know how different this rent out is from the ground rent we pay on our leases.
Okay.
How different is this?
Thank you.
The rent out, does it affect it?
Thank you. Thank you. Thank you. And Kofi had asked a question earlier, right? Kofi said somebody gave money for him to complete the premises. Adesso, you remember? We didn't answer that. So they answered that and then ground rent and this one.
Okay. So because the person invested in your, under normal circumstances, if there's any disagreement and the person is moving, the person has to be compensated because he has taken loan.
No, in that case, she gave the money to Kofi because Kofi has a building. It's incomplete.
Which is incomplete.
It says, finish it, then I'll come in. Kofi has done as much as he can. Now she says, I'm not interested anymore. Give me my money.
Okay.
So Kofi is waiting for, you know, a tenant. But nobody else is coming. Kofi is asking, what are his potential difficulties? I think he's afraid that there may be some crime.
Yes. You know, some of landlords also play tricks. Okay, so when it comes to such circumstances, we still have to invite the two, listen to them well before we can adjudicate satisfactory.
Right.
So if Kofi likes, Kofi can come to our office, lodge the complaint, we'll invite the tenant or the prospective tenant and then try to solve their problem amicably.
However, this was a mutual agreement between the two of you. It's a private contract and there's no crime in it. But where you are found to be deceiving the person, you have the money to pay back, and today you are dodging, tomorrow you are dodging, evading, not wanting to pay, that one, it can later on metamorphose into fraud and you can be guilty. Yes.
So with child issue, as I mentioned, it's not every land property owner who is a landlord. You can build your house and you are mandated to pay this property rate. After paying that property rate, when you give your premises out, then and you collect the rent advance, you will also be mandated to pay this rent tax, which we normally factor into the rent. So in effect, it's the person who is coming to occupy the premises who pays. But it's mandatory that as a landowner or the property owner, you pay this property rate. And then indirectly, you pay the rent tax as well.
Okay.
Yes, so that's the difference.
Right. Thank you so very much. And like I indicated to you, we will have a part 2 for him to answer all your questions about rent. Now, if you are watching us, look on your screen. You see a number. That's a WhatsApp number. It's 054 010 9009. 054 010 9009. Or you can send an email to joynews@multitvworld.com. Send ahead of time any of your issues, any of your questions, and at the right time, we will bring him back and then we will get answers for you. Today, if you missed anything, remember that as a landlord, first, it is important that the agreement that you have for your tenancy, it should be in writing. If it's not in writing, it's not in your best interest. Even you, the landlord, it might also go against you, but it is not unlawful, but it is the best. Number 2, make sure once the property is finished, you do an assessment. You go to rent control, they'll do an assessment for you and give you the permission to now rent the premises. After that, when you have a tenancy, the agreement, you lodge it with the rent office, and then you issue the cards that are required. They are in their offices. You can pick them, and then they will make them available to you as well. We will look at other issues that you need to know, and know that you may be committing a crime if you take rent advance in excess of 6 months. Thank you so much.
What do you have here?